security of the Internet of Things, a very hot topic in privacy and data security law right now. My name is Andrew Baer. I head the Technology and Privacy Practice Group at Baer Crossey McDemus. And our goal today is to look at some of the regulatory issues in the privacy and data security world that are coming up in what we call the Internet of Things, the global and increasing network of devices and applications that collect data and share it over the Internet. What manufacturers and sellers of these devices should think about in terms of avoiding government action and maintaining a good reputation with consumers. Just to give you an overview of what we're going to cover, we're going to go through what I call a classic horror story involving an FTC action against TrendNet, a manufacturer of a baby monitor connected to an app. Then we're going to go over a few of the high points of recent Federal Trade Commission guidance regarding the Internet of Things that came out a few months ago, containing principles and privacy practices that manufacturers and sellers of Internet of Things devices should keep in mind as they go forward. We're going to be talking about privacy and security by design, first of all, how you can think about privacy when you train your employees, when you build and test your products, when you look at your product's interoperability with other devices. We're going to talk about data minimization, how much data to collect, when maybe you shouldn't collect as much data at the beginning, maybe defer a little bit of data collection later. And if you change your data collection practices, how do you message consumers about that? Finally, we're going to be talking about notice and choice. What options does the Federal Trade Commission require you to give buyers of your devices to ensure you're properly messaging privacy policies and giving them choices about the use of their data? And in the Internet of Things, this is a particularly salient topic because unlike with a desktop application per se or a website, often it's not very easy to communicate a standard privacy policy. How do you do that, for example, on a thermostat or a skin patch? Very interesting topics. We'll get into some of the options there. Before we get into the TrendNet horror story that I mentioned at the beginning, probably be good to give you a high-level 20,000-foot view at privacy regulation in the United States and why we're concerned about the FTC in particular. Unlike other jurisdictions, for example, Europe, there is no general privacy law in the United States. Certain types of data in certain industry verticals like health or financial services are regulated by various statutes, but there is no general privacy statute that applies across all types of businesses in the United States. There's a patchwork of state statutes, but so far nothing holistic at the federal level. So into that void, into that absence of a comprehensive national privacy regulation, the Federal Trade Commission has stepped. And the Federal Trade Commission over the past 10 or 15 years has gotten increasingly assertive in this area, in some ways expressing its frustration at the failure of Congress to pass some sort of global statute. The FTC gets its authority to regulate privacy and data security in the marketplace from the Federal Trade Commission Act, which was passed something like 70 years ago, I want to say. And that act doesn't say anything specifically about privacy, but there is a special provision of that act, Section 5, which gives the FTC the ability to create rules and bring government enforcement actions against unfair or deceptive acts and practices. Clear as mud, right? What's an unfair or deceptive act or practice? As I said, this statute went into effect decades before the Internet, decades before the advent of computers and mobile devices. So the FTC has essentially taken this statute to mean that anything that it considers unreasonable, anything that it considers unfair, against consumers' expectations when buying or interacting with a product could be an unfair or deceptive act or practice. And the FTC has used this statute, Section 5 of the FTC Act, to, among other things, require web businesses to issue privacy policies, something we're all familiar with, to offer consumer's choice in certain situations where personal data or potentially personal data is going to be shared in an unexpected way, and also to use reasonable measures to protect data security. That's where we're seeing a lot of action lately. The Federal Trade Commission considers it an unfair trade practice for a company to fail to use whatever it considers reasonable security measures to safeguard consumer data. So that's, in a nutshell, the regulatory regime that we're acting under. So looking at specifically the Internet of Things, what we're trying to do is we're trying to read the tea leaves and say, okay, what is the FTC likely to consider an unfair or deceptive act or practice in the context of the Internet of Things? And fortunately, the FTC, or perhaps not so fortunately in some cases, the FTC did issue guidelines in early 2015 to this effect. FTC guidelines, and I'm just giving you some experiential perspective as someone who reads a lot of these. They're kind of funny in that they often say at the front, this is non-binding, and these are recommendations to Congress and best practices for companies to follow. There's a lot of loosey-goosey language, that suggests that companies should take these under advisement, but they're not legally binding. But what I will say is, if you think that, you think that at your peril, because these guidelines that are periodically issued every few years do provide a roadmap to the FTC's thinking in what it considers an unfair, deceptive trade practice. So if you violate or flagrantly violate any of these guidelines, you may find yourself at the tail end of an FTC enforcement proceeding, which can involve privacy audit and oversight for up to 20 years, fines, restitution. Needless to say, lots of legal fees are all things that growing companies who want to put their money into their products, not legal fees, and who want to maintain a good reputation with consumers want to avoid. So that perfectly tees up the TrendNet example, and this was one of the more high-profile FTC enforcement actions in the Internet of Things. TrendNet marketed a baby monitor, a baby monitoring camera that was tied to a mobile app, so that if you were downstairs or if a babysitter was watching your baby and you were out to dinner, you could watch your baby peacefully sleeping on your phone or your tablet. I'll say, as a new father, I had considered buying this product myself. Kind of glad I didn't, given what happened. So, as you might expect, in marketing a product like this, which would involve streaming video of peacefully sleeping children across the web, TrendNet was very interested in conveying to its consumers an impression of security, that it was doing everything it possibly could to maintain the security of those video feeds. So they made all sorts of representations in their marketing materials saying this is a highly secure solution and you should trust us. But it turns out that they did not implement what even then were considered industry best practices in data security. So they transmitted user login credentials in clear text over the internet. The use of their solution resulted in the storage of login credentials in clear text on mobile devices. They didn't actually test their privacy settings, so anxious were they apparently to get the product out to market. So the end result is, in thousands of cases, hackers could hack and intercept the video stream and watch the picture of people's babies from wherever they wanted. And again, as a new father of two little girls, let me say that that's as creepy as it gets from my perspective. So the FTC stepped in and took a look at this. It was a very high-profile case, and specifically it focused on these representations that TrendNet was a highly secure solution. And the FTC said that this was deceptive, that it misled consumers, and that the failure to implement reasonable security practices was unfair to consumers. So what was TrendNet required to do? Well, they got a much more FTC oversight than any early-stage company would want. They were required to establish an information security program to address security risks that could result in unauthorized access to the devices, to take other steps to protect the security, confidentiality, and integrity of information stored, captured, accessed, or transmitted by the monitors. And they were also required to dig themselves out of the hole and help consumers. contact all consumers about this glaring security issue and provide them with free technical assistance for 2 years to secure their devices or to uninstall those devices. That you do not want to be that. Anybody who is manufacturing or selling an internet-enabled device, as I said, being the subject in the FTC proceeding, is not only expensive, but it creates a toxic reputation, as happened in the TreadNet case. So that brings us to privacy and security by design, one of the 3 main principles that the FTC stressed in its recent Internet of Things report. You should build your device, you should design your device, you should test your device with privacy and security in mind, and you should try to perpetuate a culture of consciousness of privacy and security issues across your company. Some of these recommendations are pretty self-explanatory. Conduct tests before a product release. And that's what TreadNet didn't do. It seems pretty self-explanatory. At the same time, an early-stage company sometimes is very anxious to get its product to market, so can cut corners here. This is something that the FTC warns against. Incorporate smart defaults. So, for example, when somebody configures the device and there's a default password, require them to change the password when they set up the device. Address product security at a senior level. So what that means is don't have some lower level employee in a different building in charge of data security and privacy by design, who has no interaction with the product developers, who has no interaction with senior management. You need to have a senior executive level individual responsible for this. Somebody who is very much in communication with product development and the marketers, and somebody who's in a position to inculcate sensitivity to privacy and data security across the company. Promote security awareness and personnel practices. Service provider selection and oversight. This is something which is very important. If your service provider screws up, releases personally identifiable information, causes some other type of security breach, and it's subsequently revealed that you failed to investigate the the service provider at the beginning, failed to determine whether or not they were capable of living up to your company's security values, you're going to be held responsible for that. If you fail to exercise oversight over them, you could be held responsible for that. So very important. Make sure that the service provider you select, particularly if they're going to, for example, be a host or a back end, for your mobile app or your device, if they're capable of adhering to the same standards that you have to. Defense in depth. This is really an FTC term for multi-layered security. So if you can build security into the device at various levels, so that if security is compromised at one level, there might be a backstop. Try to do that. And feasibility is certainly a consideration here. It depends on the device, depends on the business model. But a couple of things that the FTC did throw out in its guidance: reasonably encrypt data in storage or transit. If it's personal data or potentially personal data, and access controls. Something especially that's important when your Internet of Things device interacts, for example, with a consumer's home network. Where you don't want to be is a situation where some hack of the IoT device results in a compromise of the consumer's Wi-Fi network, for example, and results in broader damage, broader security breaches beyond the IoT device. So you might think about how the IoT device has to interact with a network. Another example, I should say, besides TreadNet of failure to implement privacy and security by design is Credit Karma and Fandango. Those apps, they overrode the Android and iOS settings, and as a result, the SSL encryption was not properly implemented, leading to broader security issues with consumers' mobile devices. Continued communication with a user. This is a new area that the FTC hasn't messaged much in the past, so the emphasis in the recent 2015 guidance, I think, is telling. This goes to communicating product life cycle issues to the consumer, patching vulnerabilities. So, for example, if you have known vulnerabilities in in your Internet of Things product, and you know that a hack is likely to result in in a data breach, provide updates to the software to the consumer if it's a known vulnerability and that's feasible to you. Send messages to the consumer if you're aware of security risks or if updates are available. Also message the consumer if you're going to end of life your product, and that's also important. So, for example, if the consumer buys a product, for example, a TrendNet baby monitor and an app, and you decide at some point it's no longer feasible or economical for the company to continue to provide security patches and updates for this product, you want to find some way to tell your consumers that so that they don't continue to use the product and suffer as a result of it. None of this says you have to provide security patches and updates forever or have to provide infinite support. I mean, that's important to note here. Feasibility is, as I said, a consideration. But again, if you know about problems, you should message those. Try to provide patches if feasible. Or if you're deciding to move in a different direction and you're no longer going to update the product, message the consumer so that they can make an informed decision about the risk. Data minimization, the second of the three principles the FTC talks about in the guidance. And this is really about not collecting any more data than you need at the moment for your legitimate business purposes, not holding on to the data for any longer than you need for your legitimate business purposes, disposing of it securely, really thinking about what your business needs are today and in the near future, and making sure that you tailor your data collection practices to what your business needs, but not an unnecessarily greater degree of data collection. Why is the FTC interested in the amount of data that you collect? Well, there's several issues here that could impact consumers. More data, more problems. Number one, the more data that you collect, the more types of data that you collect, particularly if it's types of data that really isn't that necessary to run the device or for the consumer to use the device, your data collection practices could deviate from the consumer's reasonable expectations of what you're collecting, which means that you need to provide a higher degree of notice and choice to consumers about your data collection practices. We'll get more into that in the notice and choice section. Secondly, and this is probably self-evident, the more data you hold, the richer a target you are for a hacker, and if information is released, the likelier the harm to the consumer that results. So the FTC, in its role of protecting consumers, is looking at the amount of data that you collect. Limit your data collection to what is reasonably necessary. Securely dispose of any data that is no longer needed. And I recognize that these principles here are, as I said earlier, clear as mud. They really depend on context. They really depend on your business model. They will be different for every company. And by the way, I mean, when you can always change, I'll say, your data collection practices. So if you limit your data collection to what is reasonably necessary at this moment, but introduce a new product feature or a new monetization feature for your business later on, you can always change those practices. You just need to think about at that time whether there needs to be notice and consent for the consumer. I think a concrete example here is good to talk about, in thinking about what we mean by data minimization and the various choices available to an Internet of Things seller when it comes to data minimization. So here's an example that I'm going to talk through that comes directly from the FTC guidance itself. So let's say we have a patch that monitors skin condition that is connected to some sort of mobile app or internet-enabled backend, and it's meant to monitor your skin condition, maybe detect red flags of issues, allow you to track certain things about about your health and about your skin condition, maybe educate yourself more about skin diseases, and that's really what a consumer buys this product for. Well, let's think about this. All right, collecting data about the state of your skin and temperature, other indicia, that's pretty much expected, right? I mean, the patch really needs to do that in order to operate, to fulfill the customer's expectations of what the patch would do when they bought it. Does the patch need to collect precise geolocation information, that I'm standing on a particular street corner at a particular time? Well, if the business model and purpose of the patch is as I just described, probably not, right? I mean, it could, as long as I can access the data on a mobile app or, or a website and track my progress, educate myself about skin diseases, identify any issues, it shouldn't really matter where I am. So that might be an example of collecting more information than is really necessary at the moment, and something that a company manufacturing this patch should think about. Does it need to collect geolocation information at the outset? So, okay, let's modify this example a bit. The manufacturer might say, okay, well, let's say I want to collect geolocation information because I want to push out messages to the consumer about treatment facilities and treatment options in their area. Which seems like a very legitimate purpose that the consumer would be interested in. Nothing really nefarious about that. All right, that's fine, but do you really need to collect precise geolocation information? Do you need to collect the fact that Andrew Baer is on a particular street corner or a particular time? Or could you just use Andrew Baer's zip code, for example? Could you limit your data collection to that? Because surely that would allow you to push out messages to me about treatment options in my area. So could the device collect less interest while still serving its purpose? Another way to think about data minimization, and companies should consider when deciding how much to collect, particularly at the outset of launching the device, is whether de-identification of data is an option. So maybe you do want to collect certain demographic or other data, maybe information about your user base, your audience is important in marketing or or improving your product. It doesn't necessarily need to be personally identifiable. Is there a legitimate business purpose to maintain PII right now? So it may be that you can de-identify this data and still realize your business purpose, for example, gaining valuable demographic insight into your consumer base without incurring the higher risk to consumers that are associated with maintaining large amounts of PII, particularly as in my prior example, health-related PII, which is considered sensitive information by the FTC. So always consider de-identification as an option. The important thing, though, is to be clear about what the FTC considers de-identification to mean. So a lot of people say they store anonymous or de-identified data, and it's very reassuring to consumers because we're used to thinking about these categories, these black and white categories of personally identifiable information and anonymous or de-identified data, and neither shall the twain meet. But the fact is, with certain types of so-called anonymous or de-identified data, it's possible to quickly reassociate them with other publicly available data sets or with publicly available data sets to quickly identify individuals. So de-identification means robust efforts and appropriate safeguards to ensure that the data is truly de-identified and it stays de-identified. So the FTC says when a company trumpets that it maintains anonymous or de-identified data, it must do three things. As I alluded to previously, it must take reasonable steps to de-identify the data, including keeping up with technological developments. So if you're aware of new data sets being out there in the market or new methods of quickly re-identifying data to identify an individual, you need to think about whether you're adequately de-identifying your data so that it stays de-identified. You should publicly commit in your marketing and your privacy policy not to re-identify the data. And if you're sharing the data with third parties, you should put provisions in your contracts with those third parties requiring them to commit to not re-identifying the data. So if I am trying to make consumers comfortable in my privacy policies and my marketing that I'm privacy conscious, that I'm only going to maintain anonymous or de-identified data about you, but then I license my database or sell my database to a third-party marketer, and that third-party marketer de-identifies it or reassociates it with other data so that it can target ads to individuals, and I should have known about that, I'm going to be held responsible for it. And as I said at the beginning of this section, businesses' needs will change. Your data collection needs will change. That's entirely to be anticipated. So if you're going to change your practices, seek consent. Seek consent to collect additional data or to use it in a new way. And we'll talk a little bit about notice, choice, and consent in a minute. So when is consent to data collection and sharing in the Internet of Things required? When is notice required? And, how do you do that? Given that we're not talking about, a website that's being viewed on a desktop application in most cases, we might be talking about a skin patch or a thermostat or some platform that is not the most conducive to reading a traditional privacy policy. How do you provide notice and choice to your consumers? In determining whether choice, and by choice we mean opt-out, giving the consumers the ability to opt out of certain data collection practices or data sharing practices, the FTC uses a contextual test, the context of the interaction test, in determining whether or not an Internet of Things seller should provide consumers choice. And that test, by the way, is really no different from the same test they apply to mobile apps and traditional websites. It's really an extension into this new series of platforms. What is the context of the interaction text? Basically, you do not need to provide your consumers choice, i.e. an opt-out, from data collection and sharing policies if what you're going to do, the data that you're going to collect, the data that you're going to share, can reasonably be expected by the consumers based on the context of your interactions with them. So if it's something that the consumer should reasonably be aware of or reasonably suspect is going to happen by virtue of using this device, then the FTC considers it superfluous to provide an opt-out. It's really not necessary to protect consumers. But if you're going to do something that would strike a reasonable consumer as unexpected, something that they would not suspect from their previous interactions with your device, something that might rub them the wrong way, there's a precise legal standard. It's always good to provide choice, provide an opt-out. And there are various ways you can do this. And we'll go back, by the way, in a second to an example of the context of the interaction test, so you can see how this works in practice, because it really is different for every device and every business model. Let's talk about how you would offer choices to consumers. So really now we're talking not so much about when an opt-out is required, but how do you message the consumer, given that you're not operating a traditional website, but something else. It could be a mobile app, could be a skin patch, could be something really, without a screen or much of a screen at all. So how do you do that? There's no specific prescribed way, but the FTC and the guidance provide 7 or 8 choices, a non-exhaustive list of examples that you may want to consider, and what's right might be different based on the type of device, the type of company. Choices at the point of sale. When you buy the device, there might be a way to configure it with certain opt-in privacy settings. Video tutorials on YouTube. You might offer some sort of channel explaining privacy choices and ways to configure the device, or otherwise message the company with what your privacy choices are. Codes on the device. You could put a QR code on the device or some other type of code, barcode, that somebody can scan, or that basically connects or links to a website with a privacy policy or privacy dashboard and opt-out choices. A setup wizard when you're setting up the device. Privacy options could be one more item in that menu. One other thing that I should note before I go on to other options for offering choice to consumers is that there are heightened requirements for the collection of use collection and use of sensitive data. Sensitive data that is identifiable to a consumer or is potentially personally identifiable to a consumer. So for example, sensitive data that is connected to a unique device identifier, even if it's not connected to an individual's name, for example. The FTC treats all of that the same and says that if the data is sensitive and is connected to an individual or device, you need affirmative express consent for the collection and use of sensitive data. Again, another precise legal category for you, but I can give you some examples of what that means. Health-related data, financial-related data, data, for example, about sexual orientation, about pregnancy. Those are all examples of highly sensitive data to individuals that if they are used or disclosed in a way that the consumer doesn't intend could result in significant embarrassment or financial harm. And so the FTC, when looking at privacy notices and the degree of choice afforded to consumers, takes a heightened degree of scrutiny when we're talking about sensitive data that is associated with an individual or device. You need affirmative express consent. Somebody saying, yes, I understand, for the collection and use of sensitive data. So let's step back for a moment and give you an example about how notice and choice works. And again, this example is taken directly from the FTC guidance. So let's say you have the manufacturer of a smart oven. I buy a smart oven. Again, it's connected to a mobile app or desktop application. And let's say the manufacturer of the smart oven collects information to improve the accuracy of the product. So they collect information about my usage, and they use that information to make better products, maybe to provide me patches or updates to the software used with my product to make it work better. Well, if I buy a smart oven, an internet-enabled device, that's probably going to be expected by me. It should be expected by me. It's to my benefit. It really isn't the type of thing that I can legitimately claim I was blindsided by or harmed by. So the FTC has said, you know what, if that's what you're doing, you're collecting that data to improve the accuracy of the product, or maybe even communicate with me, the consumer, about other products available, other IoT products available from the same company. The FTC says, you know what, a consumer should reasonably expect that based on the context of their interaction with the device, and you don't need special choice mechanisms and opt-out for that data collection. It should be messaged in the privacy policy, whatever privacy policy is associated with the device, but you don't really need to go any further than that because it should be reasonably expected by the customer. It's consistent with the consumer's interactions with the device. So let's change the example and say, okay, let's say the smart oven collects data and shares that data, again, device or individual specific data with third-party marketers. Well, that's something that, at least according to the FTC, I as a consumer really do not reasonably suspect based on the context of my interactions with the device. That's something that, according to the FTC, I'm going to say, wait a minute, that's very strange. I didn't think I was signing up for that. I didn't opt in for that, and I'm not comfortable with that. So that's a type of situation where the data collection or use practice by the IoT company would deviate from the consumer's reasonable expectations based on the context of the interaction standard. And the FTC would require the company, in that case, to provide the user with some sort of consent mechanism, some sort of choice mechanism to opt out of that data sharing. The FTC says that notice of privacy practices and choice must be clear and conspicuous. That means prominent. Conspicuous means prominent. For example, don't bury it in mouse print below the fold of a website that the consumer may have no reason to suspect exists simply because they bought the IoT device. Getting back to the examples of how to message privacy notices and choices, maybe there is some other way that the manufacturer can hit the consumer right between the eyes about their privacy choices. Clear and conspicuous. here are some other ways they can do that. So you might have a privacy dashboard associated with the device. You might have privacy policies and options on different platforms. So for example, if you're talking about a mobile app, it's hard to read a privacy policy on a mobile app, or exercise privacy choice on that tiny screen. Maybe the mobile app, when you open it, says, please see this website link for our privacy policies and your choices. And you go to your desktop and you can view the privacy policy and exercise your options. Icons. So for example, there might be an icon if the device has a screen that hovers in the top right of the screen or some other prominent place when data is being collected or shared to inform the consumer that certain privacy sensitive features of the device are operating. Out-of-band communications to users. So for example, when you configure an IoT device, maybe it pushes out a text or an email to you saying, thank you for configuring this device, thank you for activating your device. Please visit this website for your privacy notices and choices. General privacy menus. This is an interesting idea where the device may ask you, or the person may ask you at the point of sale, how sensitive are you about privacy? Are you very, very privacy sensitive? Do you take sort of a medium tolerance of privacy, or do you not care about privacy at all? And maybe there's a set of default settings associated with each one of those general privacy levels that when you indicate that general preference, the device configures those options. You should still provide more specific information about what those options are and what the privacy practices are, but again, it's a way of honoring the consumer's choice in a prominent fashion, particularly at the early stages of product use, in a way that where this type of honoring of choice might be more difficult than, say, for a traditional website. User experience. What I mean here is, let's say you have a bunch of devices from the same manufacturer, and you have privacy settings. You've set your privacy settings at a certain level for a certain set of options on each one of these devices. You buy a new device, or maybe another device in the same network. Perhaps this device can communicate with the other devices and essentially import your privacy options and settings, obviously giving you the opportunity to change them, but at least assuming that if I exercise these options with the first 4 devices from this manufacturer, maybe it's a good bet that that I'd want the same options honored with my 5th device. So let me give you another example. And this is an example with a Wi-Fi enabled thermostat where the privacy choices just aren't available directly on the device like you would see in a traditional website or even an app. Maybe it is best in connection with this device for users to go to a website or app to choose their privacy and security settings. So maybe maybe the device sends you to a website, sends out a text or an email. Please make sure you visit this website for more information about our privacy practices and to exercise your privacy options. One thing I should say also before turning it over to questions, let's go back to the clear and conspicuous standard. I emphasize the conspicuous angle of it. Let's talk about clear, because this is another tea leaf, if you will, into how the FTC is thinking. Clear means plain English. One thing that we're seeing a lot at the legal level is more and more frustration by the FTC and sometimes class action lawyers at really Byzantine 10 or 15 page privacy policies where the really important stuff, what the companies are really doing with your data, particularly the unexpected, like behavioral tracking, et cetera, all that stuff is buried in legal language on page 12 of the 15-page privacy policy. The FTC is saying more and more these days that's not clear. We don't like privacy policies. You have to have them, but we don't necessarily like them because they're highly legalistic and not clear. We want companies to communicate information, vital information about privacy practices and privacy choices outside of the privacy policy in ways that consumers can understand. You see these, you see this evolving culture. For example, when you use an iPhone or an Android, you have various privacy dashboards. You get various notifications when various apps are collecting information. These are examples of how we're gradually moving away from traditional privacy policies to more consumer-friendly and plain English types of disclosure about data collection and sharing. Something very important to think about, especially with the Internet of Things, because as I said, in many cases, the consumer is going to be even further removed from a traditional website privacy policy than they would in other contexts. You know, they may not even have an opportunity to see a website privacy policy until after they've activated and are using the device. So companies should be creative in thinking about how to message their users about privacy and and privacy options. So wrapping this all together, I mean, what does this all mean? Wrapping it up. Companies should not be terrified of this. While the guidance is about 60 pages long and contains a lot of opaque words like clear and conspicuous and context of the interaction test, really what it's about is doing a risk assessment when you build your product, making sure that there's somebody high up in your company who's thinking about privacy and security. If you're aware of security issues and risks, try to address them, if feasible. Try to be upfront with your consumers in communicating what you do. Think about, what you really need to collect on day one and what you might need to collect many years later. And even though companies never like to change their privacy practices or seek additional consent to collect new types of information, at the end of the day, there are ways of doing this, that are not too disruptive. So really think about, in data minimization, what do I need to collect on day one? What do I really need to do to effectuate my business model in selling this device now? Just on a personal note, a lot of clients of mine love to collect lots of data on day one, and I ask them when creating their privacy disclosures. So great, what are you going to use this for? Because I have to state this clearly in the privacy policy. And they say, we don't know. We think it would just be a good thing to have. Well, that's precisely the type of situation where you don't want to be with the Internet of Things, given the risks of data breaches, of failures of mission-critical devices, especially if we're talking about something like a thermostat or a health monitoring device, compromising the security of a customer's Wi-Fi network. Really think about what you need now, maybe in the near future, and keep thinking about that. Keep doing risk assessments. Keep asking yourself, what do I need to collect? Do I really need to keep it? Are there other ways I can maintain this information that are less intrusive, less insecure, as that business model evolves? With that, I've spoken for about 45 minutes. I know I've said a lot. People probably have questions. I'd like to turn it over to the audience. Happy to spend the next 15 minutes answering any questions that you have. One of the audience members asked, how do we ask questions? I believe in the GoToWebinar interface, there's a questions menu that you can do that and just type in your questions. And if you do that, it's going to show up on my screen. I have access to that same questions menu, and I can see what comes through. Well, we don't seem to have any questions so far. I will stay on for another couple minutes in case anyone has any questions that they want to ask. If not, thanks so much for attending, and please stay tuned. We hope to have more webinars on privacy and technology issues in the law this year and going forward. One question came through. Do we have a sense of how the Wyndham case may affect the scope of the FTC's ability to regulate the IoT? Excellent question. The Wyndham case is a seminal case right now in the Third Circuit Federal Court of Appeals, challenging the FTC's authority to regulate data security. So I said at the beginning of this webinar, the FTC has stepped into the void as the de facto privacy and security regulator in the United States. Wyndham Hotels suffered a data breach. The FTC went after it and sanctioned it for failure to implement and maintain reasonable data security standards. And Wyndham basically is saying that the FTC doesn't have the authority to do this. Well, I mean, the short answer to that question is if Wyndham wins on that particular issue, you can bet it's going to go to the Supreme Court. My guess is that the Third Circuit would not, how shall I put this? Now I'm really getting into sort of legal procedural jargon. Would not implement a decision in favor of Wyndham immediately, recognizing that this is an issue of historic national importance that the Supreme Court would have to address. So my guess is nothing would happen immediately. It would go to the Supreme Court. But if I'm wrong, and the Third Circuit Court of Appeals or later the Supreme Court decides that the FTC does not have this authority under the FTC Act, then a lot of this regulation of the Internet of Things at the FTC level would go away. There might still be some regulation of it. So even if the general Section 5 authority were not applicable to privacy and data security, there are still federal statutes like the Graham-Leach-Bliley Act, like the Children's Online Privacy Protection Act, which specifically give the FTC authority to issue privacy regulation in certain areas, applicable to certain types of data. So, for example, in COPA, the Children's Online Privacy Protection Act, the FTC does have the ability to issue regulations about the collection and use of personally identifiable information from children under 13. So it would still regulate in that area in the Internet of Things, even if Wyndham won in the case. Excellent question, though. Let's see if we have anything else. One of the listeners asked, do you have information or case studies on other companies associated with privacy issues, basically to learn from them? Not quite sure what you mean by other companies associated with privacy issues. If you mean companies like TrendNet that have been the subject of FTC enforcement proceedings because they did something bad in privacy and data security. I mean, a great way to find that out. I mean, there's a lot of information on the internet about it, but the FTC in its press release section often touts successful privacy enforcement proceedings against companies like that to show that it's doing its job as a government regulator to protect consumers and the public. So you can find out more information about key proceedings there, or we could, we could probably provide some information as well. One of the listeners noted there's a bad lag between asking questions and them getting through to me. Yes, I apologize for that. It appears to be a minute or two before they get through. So as I said, I'm sorry for that. I would ask that you just have patience. I'll make sure that we get to your questions. So far, I haven't seen any more questions. Given the lag that I just noted, I'll stay on for another minute or two just to see if anything else comes through. But it looks like there are no more questions. Well, thanks again, everybody, for attending the webinar. I hope you found it informative. I have my contact information on the last slide. Please do not hesitate to contact us if you have any other questions or you'd like more information about this important topic. And please stay tuned for information about other technology and privacy-related webinars coming soon from us in the near future. Thanks again, and you've been a great audience.